Welcome back. Dennis Kennelly, you're on the legal line. Our guest today, Peter Marks, noted mediator and arbitrator. Our subject, mediation. And we're at the point right now, we were explaining the three stages at which you can choose to mediate a case. What we're doing here is mediation is part of what's called alternative dispute resolution, which under the California Rules of Court and also under the Federal Rules of Civil Procedure and local rules is something in which you have to engage. You don't get a jury until you've tried to settle it some other way. So mediation is one of them. Now, we were talking earlier, right before the break, about a situation where the parties agree to sit down even before a lawsuit is filed. For a variety of reasons, one of which is neither side wants the publicity, and everybody wants confidentiality, which is a good idea. Now, Peter, do you see many of these?
I'm starting to see a little bit more, and there are a few reasons for that. One, well, you've described a couple of them, and those are very important. Another factor, quite frankly, is that whether we like it or not, in America, it's basically equal justice for the rich. At least that's my perception. And litigation is incredibly expensive and we don't, that's a whole other discussion as to why that is. But lawyers often do their clients a great service if they think it's in an appropriate case to enter into a mediation or other form of settlement, other settlement process prior to initiating a lawsuit. Because once you file a lawsuit, the money can start to go out of your wallet very, very quickly.
Oh,
and
yes.
So, look, there are some problems with it. It's not appropriate for every case, and I don't know, Dennis, if you want me to go into the reasons for that. But it can be very useful and very helpful for a number of reasons, certainly including cost, confidentiality, and just the time demands which a lawsuit invariably makes on a client, because a lawyer can't do a good job for his or her client without the client's participation. The lawyer relies on the client for information, and there'll be all sorts of points in time in the lawsuit when the client's participation will be required, and it can be very, very extensive, hours and hours, days and days, especially as you get closer to trial. So the client still has a life, presumably, a job, and hopefully a job and other activities that family and so forth that occupy a certain amount of time, as they should. And a lawsuit can be incredibly disruptive to all of that. And so that's another factor for supporting early mediation.
Now, early mediation, my experience has been there are two kinds. There are the ones that are successful, and I've had these, and I've also had ones that blow up. They blow up, in my experience, because if both sides don't check their egos at the door, and you wind up without sufficient information, you wind up with the plaintiff's counsel beating his or her chest and saying, I'm going to absolutely crucify you in front of a jury. Your cross-examination is going to leave you in shreds, and I'm going to walk out a millionaire. And the defense always comes back with, we're going to get rid of this case on summary judgment, which means it never gets to a jury. And you'll have spent a lot of time and money, but a judge will rule that this case never gets to a jury, so why should I pay you anything? And those cases don't work because there's no discovery. Both parties haven't really exchanged any information about the true facts of that case.
Well, I was actually in a position.
This is Nikki London,
Hi.
by the way, our producer, who's got a question.
Hello, Nikki.
Hi, how you doing, Peter? Thanks for joining us today.
I'm Vertical. How are you?
Good, good. I just had kind of wanted to chime in a little bit. I was in a position for a little while where I worked in a collections department for a small business, and a lot of times what I was finding in the situation wasn't necessarily, of course, this was of non-payment of their bill. And a lot of times I was finding that they were dissatisfied with the services, things like maybe the people didn't show up for this to provide the services, or whatever the situation was, and that nobody was really taking the time to discuss with them what the actual issue was. And I feel it kind of I would have to go to small claims court for these cases. And before we would get to that point, I myself would try to get to the bottom of it and see if there was maybe some kind of middle ground that we could come to, depending on what the situation was. Maybe that would work. I think you see that a lot in small businesses, because, they're low-paying jobs. I think that kind of maybe has something to play with that too, because you're, I'm getting a little off track on that, but with smaller businesses, you can't afford to have lawyers and going into court cases and things like that. If you have somebody within the company also that kind of helps resolve those issues, I just think once, like you were saying earlier, getting to what the real issue is, what's really motivating them to not want to follow through with their end of the deal, like with the contracts that you would sign for a service, maybe for a year, whatever hasn't been obligated to them in that time. They feel like they shouldn't have to pay for that.
Well, you've raised a couple of good points. A lot of times, it's, as Paul Newman said in, I forget what the name of the movie was, we have a problem of communication.
There's a failure to communicate.
Yeah, that's right. Yeah, with that Cool Hand Luke, I think, I can't remember.
Yes, it was.
It was a great film. Anyway, and that's true. And sometimes the parties have never really, they've been kind of shouting past each other like two ships passing in the dark, and they never. And for example, the small business owner may not be aware that that one of their employees perhaps didn't show up on time or didn't complete the job, whatever it was. I don't know what the business was. It doesn't matter. And once that's communicated, assuming everybody's acting in good faith, you say, well, okay, I understand why you didn't pay, but we did do ABC. We kind of messed up on D, but shouldn't we get paid for ABC? Then the other side will say, yeah, but because you didn't do D, that cost me more money.
Right.
So, but once you get all those facts on the table, you increase, almost exponentially the chances at resolution. The other point that you actually mentioned explicitly, and that I alluded to earlier, is that, and I've meted many cases with small businesses, and the smaller cases are often harder to resolve than the big ones, and because there's so much more at stake, relatively speaking, and they can't afford, most of the time, for them to litigate all the way through trial would cost more than the value of the case in many situations. Not all, but in many situations. And so there's a strong incentive to settle, and if people are realistic and demands aren't, off the charts, that provides an opportunity for avoiding, what may be a meaningless victory. The employer might win, but might be broke at the end of the victory because they spent so much on the litigation costs.
Sure.
So both points you raised, I think, are highly relevant in terms of considering the relevance and the usefulness, the utility of mediation.
Well, and I think also in a lot of those situations that I particularly handled, once the issue was resolved, that company wouldn't necessarily lose that client as a customer.
Exactly.
It's, look, this happened. I'm not going to pay you for it. This is the situation, and until you resolve it, but the fact that companies work with their clients on a more personal, not personal, but a little bit closer in hand to really find out what their customer needs are, then I probably have a little less of that going on.
Well, yeah, it's like winning a lawsuit and losing a client. The end result may not be particularly beneficial, and that goes to the party's interests. Remember, we spoke about that. The position in the lawsuit is you owe me the money. The business owner saying you owe me the money. Period. But their interests are in staying in business, making a living at it, hopefully making a decent living at it, and retaining your clientele. So that's, again, the lawsuit's just going to decide the instant dispute. So the client may prevail in court, but may lose a client. The business owner may prevail in court, but may lose a client. Whereas in the mediation, the business owner may be able to recover at least part of what's owed, and may
retain
benefit
their
from
customer.
the continuing business of that same client.
And if you retain the customer, you'll wind up making up for the amount of money that you lost by not collecting. So
Exactly.
it's a win-win for everybody.
And that's what you call the party's interests, the true interests, and that's the mediator's job, is to try and assess that and get to that and focus on that
as soon as possible in the process.
Yeah, but sometimes it takes time because parties sometimes don't completely recognize what their real interests are because they get so wrapped up in the dispute and they're so angry. And you've got to first kind of take a step back, let them talk a little bit, and then slowly get to what's really bothering them. And that sometimes can take a little while.
Oh, it's interesting. I call it the witching hour, and I'd be interested in getting your take on this. Most mediations start at either 9, 9:30, or 10 in the morning. And for some odd reason, 4 o'clock in the afternoon is about when I discover, if you're still at it and haven't blown the darn thing up, that's when the serious discussions start.
That's a very interesting observation. My practice is to let the parties talk, probably longer than I should, because I want them to feel that they own the process, and that they're being heard. And so I'll let them talk, and it does go a little longer probably than it should. But you're right, around 3 or 4 o'clock, what starts to happen. That beeping is my other line. Just ignore it. It'll go to voicemail.
Somebody wants to hire you to mediate.
I hope so. But I hadn't used the term the bewitching hour, but it's certainly an interesting approach. And you start to see, and then the hard work really begins. And I tell them, you've been here 3-4 hours, whatever it is. I usually start at 10 and work right through lunch because, although we haven't talked about this yet, usually the parties are in different rooms. So, as you know, I'm with ARC, Alternative Resolution Centers, but all of the major providers of neutrals provide meals now and food all day long. And that's important because, particularly in the old days when we had more of what's called joint sessions, and we haven't talked about this, but that's when everybody sits in the same room with the mediator. The Daily Journal, which is as you know, of course, the legal newspaper, the newspaper serves the legal community, profiled me a couple times, and once they quoted me as saying everybody started eating pastries, and 2 hours later we settled the case. And I won't bore you with the whole story, but that's exactly what happened. People break bread together, they start to relax. So when I'm mediating, and most of the time now people are in separate rooms, each side's in a separate room, one side will go get lunch, which we serve, in a kind of a buffet style. And while they're getting lunch, I'm in the other room working with the other side. Then I send them off to get lunch, and I go back to the other room so that I don't stop all day long, and we make the best use of the time. But when people are eating and drinking and relaxing a little bit, then they start to mellow out, hopefully.
I think so.
If they don't fall asleep. And then they start to reflect a little bit and get a little bit of perspective and put it in context, and then slowly we start to get down to the nitty-gritty, and then the hard part begins.
Oh, absolutely. I think one of the key things is why mediation works a lot better than without an entire day dedicated to it, is the parties become more and more committed to the process the longer they're there. And with the help of the mediator, and it's, hey, we've gotten this far. Let's see if we can get this darn thing resolved.
Exactly. Once you've got a certain amount of time invested in it, you say, I don't want to do this again. Let's get it over with. And also, as time goes by, I said earlier that when a person's been living with a dispute for quite some time, maybe a couple of years or more, by the time they get to mediation, depending on whether it's early or not, and they're so wrapped up in their positions, they lose perspective. So you can't expect to change that in 10 seconds, but you start in the early stages of the mediation, you start, posing certain situations which maybe contain ideas which are a little bit different from what their thinking has been. Well, you can't accept them to abandon everything that they've so fervently believed in overnight or over the next 10 minutes, but as the day progresses and people eat and relax a little bit, they start to reflect a little bit.
They start to get a little sympathetic to each other.
Exactly, or at least re-examine their own positions.
Mm-hmm.
Okay. one of the things I want to go into because of the separate rooms is you've got what I call the employee's room and the employer's room. And the employee is normally the plaintiff in an employment case. So what do you find as to dealing with plaintiffs, what the obstacles to settlement are?
Generally, and this is not true in every case, but my experience has been unrealistic expectations. And frankly, sometimes that's the lawyer's fault. They say, "Oh yeah, we're going to kill him," and we're all going to, go.
We're going to retire on this case.
Exactly. And on the other hand, sometimes the lawyer, in spite of their best efforts, has trouble persuading the client that this may not be your retirement. There are some weaknesses in our case, and we have to be realistic. I'm not doing my job as your counsel if I don't explain those to you and warn you that this could be a problem and that you can never assume you will win. No lawyer will ever assure his or her client that they're going to win. In fact, there was a malpractice lawsuit filed in the last couple of years against a major firm, in which the allegation was, I don't know if it's true, was that the lawyer said you got a 75% chance of victory. Now, I'm not sure that's grounds for malpractice, but the point is, lawyers have to be prudent and have to be cautious. Obviously, a lawyer's not going to take a case, at least on the plaintiff's side, if they don't think they can prevail, especially since in many of those cases they're on contingency, so they don't get paid if they don't prevail. But there's an element of risk in every case.
Absolutely.
And as a mediator, I will often, and this is a common mediation approach, ask each side, before you dig your heels in, before you draw the line in the sand or cement or whatever, think about what do you have to lose? Or there's the BATNA concept, best alternative to a negotiated agreement. What happens if we don't reach a deal? What's
the next step?
What's the best thing that's likely to happen if it, in a perfect world, if all goes well? And what's the best thing that's likely to happen in a real world where not everything always goes well? You want to stimulate thinking.
Absolutely. We're about to go to break. We'll talk about obstacles to settlement with defendants, employers, and we will be back on the legal line after these words. Our phone number is 661-298-5487. Peter Marks, Nikki London. Welcome back. Phone number is 661-298-5487. I'm Dennis Kennelly. Peter Marks is our guest, noted mediator, arbitrator. And we're talking about mediation. And we just went over the problems that mediators encounter with the plaintiffs, namely unreasonable expectations, which are a little hard to knock down, but can be. Now, what do you find with defendants, with employers? What are the obstacles to settlement to them?
The classic response that I see, and I'm sure you do as well, with considerable regularity is, well, I don't want to settle this case because then every other employee is going to bring the same claim. And we respond, the response is twofold. I say, first of all, if we reach an agreement, it will almost invariably have, and if you insist on it, I'm sure it will have, a confidentiality clause, so that not only is the confidentiality imposed by the state law, at least as to future legal proceedings, but also we'll put a confidentiality clause in the agreement which says you can't talk about this. And the plaintiff, the employee, will be prohibited from talking about that. And you can even put some teeth in it, and sometimes people insist on this, sometimes they don't, for what's called liquidated damages, which is a clause which says if the plaintiff does talk about it, each time he or she does,
there's a fine.
It's basically a fine. It's called liquidated damage. It can be $5,000 or $2,500 or whatever. So that's a little bit of an incentive not to speak. But my experience has been, well, let me put it this way. I have never heard, I've been doing this over 25 years in many employment cases, among others, and I have never heard, nobody's ever come back to me and said that somebody breached that confidentiality requirement. Never. And often when I mention this when I'm talking, we're going over the details of the proposed settlement, and I'd go over this with the employee, the plaintiff, and his or her attorney. Excuse me. I stressed this, and I said, this is serious. This is not just some language on a piece of paper. You really have to, you can't even tell your spouse if you want to be really safe. You can discuss it with your lawyer and maybe your accountant to the extent there are tax consequences from the money you'll receive in this resolution. But that's it. And this is a very serious clause. And often the employee, the plaintiff, say, look, the last thing I want to do is ever have to talk about this case again. It was a miserable experience in my life. I want to forget about it. I don't want to discuss it with anybody. I don't want to have to think about it. It's just not going to happen. And as far as I can tell, that's been pretty well borne out by experience. Nobody has ever come back to me and said, oh, that employee told everybody, all his former coworkers, and they're all suing me now. Never heard of that, ever.
I've had a similar experience. I have never, in 40-plus years of practice, I've never had it come back. And what I tell employees is very simple. None of these people were helping you fund this lawsuit. So if anybody asks you about what happened, you simply tell them, I resolved it, and smile. Because if you tell them any more, it's going to cost you money. As I said,
well, sometimes,
as I said, they didn't provide you with any money to pay your expenses in this lawsuit. Why should you provide them information that cost you money?
Well, sometimes we'll even put in language that says nobody may say anything about this except the plaintiff, if they wish, may say, the case resolved and I'm satisfied.
Yeah.
And we'll put in the actual words.
Oh, absolutely.
The actual words that they may say and no other words. I've seen that, not a lot, but I've seen it in a few. I had a series of relatively high-profile cases in the entertainment field, as a matter of fact. That was a seriously negotiated question. And we finally resolved it that way with, I can't remember the exact words, but it was something like that. The case settled, and I'm satisfied, and yeah, that's it. That's all they can say. And everybody was happy with that. And I've seen that in a few cases, not many. Most of the time, it's just a straight confidentiality clause.
Yeah, the other thing that comes up that I hear from employment clients when I'm representing the company is the company representative, especially if it's sole proprietor or somebody that's got absolute control over everything, they will say to me, I would much rather pay you than pay the idiot that's suing me. And what I say to them, I look them in the eye and I say, let's be honest, you would rather pay neither of us. and I'm going to cost a lot of money, and if I cost a lot of money defending you, I can't guarantee anything. As we said earlier, any lawyer that guarantees a win for his client is either a liar or a fool. And I would say definitely has committed malpractice. So,
interesting.
What you've got to do is get the client to be realistic and get them off their high horse and get them to treat this as a business decision. Now, there are rare cases where it's not a true business decision, and that's called a bet the company case, where somebody's really got you by, you've really done something bad. And I've had a couple of those, and you've got to face it realistically. If you lose,
you raise a good point. I'm sorry.
If you lose, and you have to be honest with them and say, and oh, by the way, we will, you could run the risk of losing the company. So those are rare circumstances.
Those are their interests that are coming to the fore. But you raise a good point. It really is a business decision. Mediators like to say, it's not about proving a point. We're beyond that. It's not about proving a point. It's about making a deal. It's a business decision, and it's just what really will work for you to let you get on with your business and not be dragged down by this continuing litigation in which nobody wins but the lawyers.
Absolutely. Peter, I'm going to have to cut you off now.
Okay.
But we have just scratched the surface here, and I would hope on a future Thursday to have you back. Next week we'll be talking about the perspectives from both plaintiffs and defendants in employment suits and what both sides go through, which I think will be interesting. I've got one of my colleagues, the Desert Fox, Jack Fitzgerald from Palm Springs, who is checking his schedule and hopefully will be on with us. Look forward to talking with you next Thursday at noon. This is Dennis Kennelly. You've been on the legal line. My engineer has been Aaron Delatorre. My producer, star of London Rain, Nikki London.
Thanks for listening.
Oh, our pleasure. I've been listening to you, and the audience has been listening to us. So have a great week.